now.
The 5th District Court of Appeals in Dallas, Texas is now in session. Justice Peterson presiding.
I'll go ahead and call case number 0519-01505-CV in the matter of the Ruff Management Trust. Are both sides present and ready?
Yes, Your Honor.
Yes, Your Honor.
This is Bob Arnett appearing for the appellants, Tracy Bakshi, Kelly Frazier, and Mark Ruff.
Mark Dunheiser for appellee, Suzanne Ruff.
Okay. Y'all, I assume y'all are familiar with our timing system. On one of your screens, there's a timer, 20 minutes for the appellant, then 20 minutes for the appellee, then 5 minutes rebuttal for the appellant. When it's yellow, you're running out of time. When it's red, finish your sentence or respond to any questions from any of the justices. But when it's red, go ahead and stop. We've got ahead and behind, so we're trying to keep on schedule. The panel is particularly interested in the parties addressing the jury trial question. So if you could make sure and address that in your arguments. Mr. Arnett, you may begin whenever you're prepared.
May it please the court, there are 3 issues that I would like to address with the court. Number 1, what was the decisional record before the probate court? Number 2, in light of that decisional record, did the probate court abuse its discretion in modifying the trust and effectively removing the appellants as co-trustees? And number 3, did the appellate court or did the probate court err in not affording appellants a right to a jury trial? In light of the court's comments, let me address that last point first. I think it is undisputed that there was a perfected right to a jury trial. There was a demand for a jury trial. There are actually 2 filed, one dealing with the modification of the trust and one dealing with the removal of the co-trustees. Jury fee was paid. And at the September 17th hearing, the counsel for the appellants at that point specifically said to the court, I have tendered to the court our jury demand for removal of the trustee. The El Paso Court of Appeals has held that the court must give us a jury trial on any question of fact. And that was in the context of the court having heard testimony and received some exhibits into evidence, and then telling the parties that there was going to be another hearing, that the court, the probate court, requested that the parties provide some briefing, and that after that briefing, actually the question came from counsel for Suzanne Ruff, that there will be another hearing and we'll introduce whatever evidence, other evidence is needed. And the court said, yes, yes. So the standard under the this court's decision in SunWest Reliance is once a party has perfected its right to a jury trial, in order not to waive it, it either must object on the record to the trial court not giving it a jury trial, or indicate affirmatively in the record that it intends to stand on its perfected right to a jury trial. And I would submit that the appellant's trial counsel did just that. I would note that in the SunWest Reliance case, what the court focused on, and it distinguished the Texas Supreme Court's case of Citizens State Bank versus Caney Investments, because, and this was they had to go back and look at the dissent in the Court of Appeals decision in that case. And in that case, the Supreme Court held that denial of a jury trial was error and reversed. What the Court of Appeals noted, or the dissent noted in the Court of Appeals, was that the bank at the hearing had told the judge, we have paid our jury fee, and that was sufficient. So here, given the context, given the circumstances, there was a, quote, affirmative indication in the record that the appellants intended to stand on their perfected right to a jury trial. And therefore,
what were the disputed fact issues for a jury at that point in time?
Well, Justice Whitehall, the disputed fact issues go to whether, the elements for both modifying a trust and removing a trustee. Was there some waste? Was there a situation where where there circumstances not anticipated by the settlor that required an order to further the purposes of the trust? So changed circumstances would be a fact question. Was modification necessary to prevent waste? That would be a fact question. On removal of the trustee, whether there had been, whether the trustees had materially violated the terms of the trust would be a question of fact. Whether that caused loss would be a question of fact. And then the question of whether they failed to make a required accounting is actually a question of law, I believe. But so there were multiple fact issues that needed to be resolved by a jury as fact finder. And failing to do that, failing to afford that jury trial right, compels reversal of the case at the outset. So let me backtrack now to what I had intended to make my first point, which is the decisional record. And the chronology here is that there was an earlier hearing. In January, Suzanne Ruff filed a motion to modify the trust because Frost Bank, the existing trustee, had indicated that it wanted to resign or intended to resign. And so Suzanne Ruff filed this motion to modify the trust. There was a hearing on that on April 1st of 2019. There was testimony taken, there were exhibits admitted. And then on April 11th of 2019, the probate court entered an order denying that motion. Thereafter, on April 29th, Frost Bank resigned, gave written notice of its resignation effective May 30 of 2019. And in mid-May, Suzanne Ruff filed another motion, this time a motion to either modify the trust or terminate the trust or to appoint a new trustee. That motion came on for hearing on September 17th, 2019. Again, it was an evidentiary hearing. 2 witnesses testified, Suzanne Ruff and Kelly Frazier. Exhibits were admitted. And as I alluded to earlier, at the conclusion of that, the probate court said, I invite you to provide me with some briefing on and focus on what the issues are before me. And then through the discussion after that, they were going to have a further hearing, but that never happened. On December 3rd, 2019, the probate court entered a 1-page order that modified the trust and authorized Suzanne Ruff to appoint herself or a third party as trustee. Now, because this was an evidentiary hearing, the decisional record is limited to what was actually introduced into evidence at that hearing. Now, Suzanne Ruff has contended that the earlier hearing was part of the record, but that's not true. And it's obvious from the conduct of the parties. Suzanne Ruff's attorney introduced some of the same exhibits at both hearings, which would have been unnecessary if that was the case. And we've cited to the Guiton versus Moreau case that dealt with, now that in that case was also a probate proceeding. It involved an executrix. But the court held that just look, you can't just take sweeping judicial notice of all those prior proceedings in the case. That if you want to be considering testimony from a prior proceeding, that testimony, the transcript has to be properly authenticated and actually introduced into evidence. That did not happen here. Further, while the court can take judicial notice of the existence of documents in its file, it cannot take judicial notice of the truth of factual statements or allegations in those documents. And that when evidence is the subject of improper judicial notice, it amounts to no evidence at all. So here, the evidence and the exhibits from the April 1st, 2019 hearing were not part of the decisional record. So we're restricted to what occurred in the court, what evidence was admitted, and what testimony was admitted, what exhibits were admitted on September 17th of 2019. And this is not simply a technical point. This was an evidentiary hearing, and we have rules of evidence and we have trial procedure rules for a reason. It's so that parties know what evidence is actually in front of the fact finder. I submit it would be a due process violation for there to be an evidentiary hearing or a trial, and then other evidence gets pulled in later or from earlier proceedings without affording the party the opportunity at the time to deal with that, to address that issue. And as I said, the parties understood that the prior record was not part of this record by their very conduct. The testimony covered some of the same ground. As I said, some of the same exhibits were admitted. And so what we are left with is, or what the trial court could properly have considered, was what was introduced on September 17th of 2019. And when we look at that evidentiary record, it's clear that the trial court abused its discretion in modifying the trust and effectively removing the co-trustees. There are, under section 112.054A of the Texas Property Code, there are 5 reasons a court can modify a trust. I think there's an argument that 3 of them might apply here. One is that the purpose of the trust has been fulfilled or it's become illegal. Mrs. Ruff admitted that the purposes had not been fulfilled. The 2 that there's most argument about are because of circumstances not known to or anticipated by the settlor, the modification order will further the purposes of the trust. Now, to analyze that, you have to look at the entirety of the trust agreement. You can't just focus on, one provision here and there. And the Ruff Management Trust, the amended and restated trust agreement, set up a structure that makes it clear that the intent there was not to have Suzanne Ruff all by herself exercising unfettered discretion over the trust assets. There are, in section 6.2, there is a succession procedure that requires that if Mike Ruff, who is the initial trustee, is no longer acting, that he and Mrs. Ruff jointly appoint a trustee, and if they fail to do so, then under 6.2b, my clients, Ms. Frazier, Ms. Bakshi, and Mark Ruff, are automatically appointed. The trust agreement says they are appointed. It doesn't say that somebody else, that there needs to be any further action. It's an automatic appointment. And then finally, if there is in subsection C, 6.2c, if there is no trustee serving and no trustee has been appointed, then the trust protectors appoint the trustee. And so my clients were appointed as trustees, both under 6.2b and under 6.2c. Other provisions that are important here are that there is a provision for removal of a trustee, and it requires the mutual consent of Suzanne Ruff and Mike Ruff, or an action by the trust protectors. My clients were appointed as the trust protectors under section 6.8, and 2 of them were also members of what was called the Trust Amendment Committee. So there was a committee that was required to act unanimously in making any sort of amendments or modifications to the trust. Finally, there is a spendthrift provision at 7.14, which is a significant factor in looking at whether the purpose of the trust is furthered by letting Suzanne Ruff make all the decisions all by herself. That's contrary to all of these provisions. It basically vitiates the succession provisions. It vitiates the role of the trust protectors. It vitiates the role of the trust amendment committee. And so that basis is not supported by any evidence.
Under Texas law, can you have a trust, an existing trust where one person is the settlor, trustee, and beneficiary?
I believe you can. I'm not aware of any authority that says you can't do that. But it sort of begs the question, what's the purpose of the trust then at that point? If you have one person who's wearing all those hats. I mean, a trust is not an entity. It's an agreement. It's an arrangement. I'm unaware of any Texas case law that says you can't do that.
Okay.
Let me address one of the points that were raised on the in the response brief, which is lack of an accounting. My clients served as successor trustees, co-trustees for a very short period of time at the end of 2009 and the early part of 2010, between the time that Mike Ruff resigned and Frostbank accepted its appointment as trustee. And there was a lot of examination at the September 17th hearing about whether there had been an accounting. Well, a couple of points. Number one, under section 7.5 of the trust agreement, a trustee is authorized to accept without audit, examination, or accounting, accounts rendered and property turned over by a predecessor trustee without incurring any liability or responsibility. So my clients were under no obligation to do that. And it further provides that no trustee shall be liable for any act or omission of the representatives of the settlor's estates, trustees of trusts established by settlor, or any predecessor trustee, which gets to one. So the main point there is all this talk about an accounting, that they should have done an accounting in this 2 or 3 month period when they were trustees back in 2009 and in 2010, is belied by the express terms of the trust agreement. That could not have been a reason to either modify the trust or remove them. Second point is, Mike Ruff is really the elephant in the room. They keep pointing to the judgment that Suzanne individually got against Mike Ruff for $49 million, probably well in excess of $60 million at this point with accrued interest. Here's the point about that, and I just read it from section 7.5. My clients as successor trustees are not liable or responsible for whatever Mike Ruff did. And because they weren't parties to that arbitration at the point where the arbitration award was rendered, that arbitration award and the judgment that confirmed it are not binding on them. They weren't parties. You have to be parties. I would also point out that, in fact, Suzanne Ruff had brought them in as parties, and then before the ultimate hearing, dismissed all her claims, non-suited her claims against them. So if there's any res judicata effect to that, it would be that they have no liability to Suzanne Ruff and are not adjudged to have done anything wrong. The other point about it is, and it really is unfair to my clients, especially considering that the judgment resulted from an arbitration where Mike Ruff decided to absent himself from the last 3 days of hearings and essentially presented no defense. So it's like a post-answer default situation. My point is, all this talk about bad things that Mike Ruff supposedly did, that has not been decided as to my clients. That is not a fact that is binding on them. If Suzanne Ruff wants to seek some relief against my clients based on what Mike Ruff supposedly did, that's got to be relitigated. That has to be decided when my clients have the opportunity to be heard and to present evidence and to argue on what happened with these assets. It's a very curious arbitration award. Finally, there is an argument that my clients never became successor trustees. That's just belied by the express terms of the agreement of the trust document. 6.2b says if nobody's appointed under 6.2a, they're automatically appointed. Now there's argument about, well, there's a notice provision. No, there's no notice required under 6.2b. The only requirement to provide some sort of written document is in 6.2d. And that only requires that the instrument that appoints a trustee be provided to the trustee, the appointed trustee. Well, that's my clients. So there's no failure of a condition precedent. There is no condition precedent to be failed. And so my clients were clearly the trustees. The filing of a motion to amend they didn't get a stay, they didn't get an injunction. And so they were appointed and they were improperly removed. And so I would ask that the court reverse the decision of the probate court and remand the case.
Thank you very much, Mr. Arnett. Mr. Donheiser, whenever you're prepared.
Thank you, Your Honor. Mark Donheiser for appellee Suzanne Ruff, and I will address the jury waiver issue first, but I want to do a couple of cleanup from what was just last said. First, Suzanne Ruff did not bring the appellants into the arbitration. Mike Ruff brought appellants into the arbitration. They were non-suited in the arbitration, but they remained parties in the probate court case, and they actively attacked the arbitration award. Appellants filed a motion to vacate the arbitration award. Appellants appealed the judgment confirming the arbitration award. They were parties to the appeal before this court. And one of the things I noticed wasn't mentioned, the most recent events, as the court is well aware, that judgment has been affirmed as to not just Mike Ruff, but appellants in this case were appellants in that case. They filed a notice of appeal. They filed a docketing statement. They did not file a brief, but they never moved to dismiss. Secondly, claims it's unfair because this was some sort of post-answer default by Mike. Well, there is no provision for a default in the rules of the commercial rules of the American Arbitration Association. If a party does not appear, nothing is admitted. You still have to prove your case. There was a trial. Mike Ruff was present for the first 2 days of the trial, only absenting himself from the final 3 days. On the jury trial issue, first off, it was clearly waived. It is not enough to request a jury and pay the jury fee. A party must object to a proceeding going forward without a jury if the trial court starts one. Appellants did not do that. They said nothing about we need a jury here in the April hearing or at the beginning of the September hearing. At the September hearing, witnesses were called, exhibits were offered and admitted, and then the hearing came to a conclusion. Only at that point, after the evidence was in, did they even mention a jury. And That's in the third volume of the reporter's record at page 95. This was a 1-hour hearing. It's at page 95. But even at that time, you have to read carefully what Mr. Wyde said. They claimed that there was a right to a jury on the issue of removal of trustees. Mr. Wyde conceded that there was no right. You have to read it carefully, but he conceded there was no right as to modification of the trust. Again, third volume of the reporter's record at 95. Remember, as Mr. Arnett correctly stated, 2 separate jury demands were filed, one on the issue of modification and one on the issue of removal of the trustees. Waiting until a hearing is essentially finished with all of the evidence in to raise your right to a jury trial is simply too late. It has been waived. Now, there was discussion that the hearing was merely being adjourned, that there would be more testimony. But afterwards, both appellants and appellee told the court that was not necessary. She could rule on the record before her. That's in the record before you as well. I don't have the page cite in front of me. I can get it if the court thinks it's necessary. What appellants gloss over here is whether they even have a right to a jury trial on this administrative issue of administration of a trust. Both of the jury demands and Mr. Wyde's argument relied on States Code section 55.002, which provides a right to a jury in a probate or mental illness proceeding. That is the language of the statute. This is clearly not a mental illness proceeding, so appellants must be relying on this being a probate proceeding. Remember, not everything in probate court is a probate proceeding. Probate proceeding is a defined term in the estate codes. It is defined as a matter or proceeding relating to a decedent's estate. That's section 22.029. This trust, this controversy does not involve a decedent's estate. This is an inter vivos trust, not a testamentary trust. Appellants went to some effort to try to prove it was a testamentary trust and failed. All you have to do is look at it. The settlor of the trust is living. She put her own property into the trust, not the property of any decedent. Therefore, section 55.002 simply does not apply. The Poe decision upon which appellants exclusively rely dealt with removal of trustees, not modification. The Supreme Court has requested full briefing in that case. It is due December 2nd. Clearly, they are interested in that issue because Poe is directly contrary to the Supreme Court's decision in Texas State Bank v. Amaro, which is at 87 Southwest 3rd, 538, cited in our brief. The modification statute clearly makes the decision on whether to modify a trust within the sound discretion of the trial court. There is simply nothing for the jury to determine. It is by very terms of the statute giving the court the right to modify it, it is given to the court.
Can the legislature take away a constitutional jury right?
No,
Okay.
but the legislature can create rights, create proceedings for which there is no right to a jury trial because it is not a cause or a determination of rights. Supreme Court specifically held whether an accounting has been made is not is a fact issue, but it's for the court, not for.
Well, so you're telling me that in a petition to modify a trust, you don't have to have an actual case of controversy between competing parties before the court has jurisdiction to modify the trust?
I'm not going that far, no, Your Honor.
Okay, because I've tried those cases.
Yes, but have you tried them with a jury? I know I'm not supposed to ask you questions, but no, you did it yourself. You modified the trust pursuant to the statute.
We filed a petition and we had a dispute that was resolved.
That's right, Your Honor, by the court.
I'm sorry, I hate to interrupt, but the timer isn't moving, and I don't know why. We've been at 10:07 for a while.
I'm so boring.
Yeah, no, that's not it at all, of course. Well, now it's moving again.
I think
Well-
we just froze.
Well, it's moved a little.
It just threw us out, but we're back in.
Okay, it's
I
not.
stopped the clock, Justice Peterson,
Okay,
when
well,
it threw us out.
okay. So if you'll start it again, I presume that Mr. Donheiser fairly has 10 minutes left. Okay, Mr. Donheiser, thank you so much. I apologize for that technical difficulty.
No problem, Your Honor. It's understandable why appellants don't want or do want Judge Thompson to forget about the 9 years of litigation with which she's lived, because it does not reflect well on them. She has been involved in this case continuously since 2011. You would have thought that during the 2 years of the arbitration, she would have had a break, but no, this case that you're now hearing was filed and became part of the ongoing controversy that the parties have taken to calling the Ruff family litigation. So appellants are insisting that Judge Thompson can't remember any of that stuff. She can't know what appellant's live pleading in this case is. She has to ignore that because that live pleading was not admitted into evidence before her. That's simply ridiculous. Judge Thompson at the hearing specifically stated she was taking judicial knowledge of the pleadings in her files. That's, again, in the third volume of the reporter's record at page 30. No objection was made by the appellants to that. She then reiterated in her ruling the actual order that she had considered all pleadings and other documents on file. Nothing could be clearer. Again, appellants did not object to that. What was Judge Thompson's ruling based on? What was her thinking? We don't know. Of course, you can't directly ask a judge, but the rules do allow you to indirectly ask the judge. You can request findings of fact and conclusions of law. Appellants did not do that. What facts did she find, if any? We don't know. What was her legal theories, her conclusions of law? We don't know. In the absence of findings and fact and conclusions of law, you must assume that any fact necessary supported by the evidence was found and any legal theory raised was relied upon. So let's get to the nuts and bolts of modification. The Property Code, section 112.054, specifically says that this is a matter entrusted to the sound discretion of the trial court. That's in subsection B. The statute was amended in 2005 to liberalize this process, to give trial courts more discretion and power. At common law, courts did not have that power, hence no right to a jury trial. But for our purposes, the most important ground for modification is subsection A2, because of circumstances not known to or anticipated by the settlor. The order, modification order, will further the purposes of the trust. Remember, Susie is both the settlor and the primary beneficiary of the trust, and the primary purpose of the trust is to provide for her needs and best interests. So what did Susie not know at the time Mike created the trust? And make no mistake about it, Susie is the settlor, but Mike created the trust. The undisputed testimony is that Mike created the trust. Susie merely signed what he put in front of her, like she always did while she still trusted him. Mike was managing her affairs, not just the trust, but all of her financial affairs at that time. What didn't she anticipate? We've gone through a very long list in our brief, but I'll truncate it for purposes of this court. For the purposes of this hearing, she did not know that he would misappropriate approximately $49 million of her assets. She did not know that she would have to sue him to try and get those assets back. She did not know that both she and the trust would get a judgment against Mike. Remember, the judgment this court just recently affirmed is not just in favor of Suzanne Ruff. The trust itself has a judgment of by now $700,000 against Mike Ruff. All of that is in the record that Mr. Arnett says you're limited to, the September hearing.
Counsel, one of the issues I'm interested in is that part of the order that would allow Suzanne to designate herself as a trustee.
Yes.
And whether that meets the statutory purpose, whether that meets the point that the trust was trying to make, and whether that's even permissible under state law.
Well, Your Honor, it certainly is permissible, and people do create trusts and appoint themselves trustees for a variety of reasons, including, how shall we say it, tax avoidance.
Well, you create irrevocable or revocable trust where you have the settlor, trustee, and beneficiary the same person, but can you do that with an irrevocable trust?
Well, first, Your Honor, this was created. When it was created, it was revocable.
Right.
Suzanne Ruff, and you've seen the record in the arbitration, was coerced into making it irrevocable. But yes, there are purposes for doing that, attempts to avoid creditors, that sort of thing. And that was the alleged purpose in this case of making it irrevocable, to avoid creditors.
All right.
So the trust's primary purpose is to meet the best interests and needs of Suzanne Ruff. Allowing Mike Ruff to have a veto power over the selection of the trustee simply does not meet that, and Judge Thompson clearly saw that. Look at the conduct of the appellants, including things that are just their litigation position in this case. They appealed the underlying judgment to this court. Their live pleading in this case is to reduce Suzanne's distribution, regardless of her needs and best interests, to pay off what they perceive as debts to the trust. In other words, they want to cut off giving her any money. That's their live pleading in this case. Don't pay her electric bill. Don't pay her water bill. Don't pay her property taxes until this alleged debt that they claim has been paid off. This, with in addition to $2,000, slightly more than $2,000 a month, is Suzanne's only source of income. Their live pleading in this case is to cut that off for a period of many months. We also know what they intend to do as trustees because they've told the court. They told the court that they intend to pay their own lawyers for the arbitration. They intend to pay Mike's lawyers $2 million for the arbitration out of a trust that barely has that much in assets. They objected when Frostbank asked for permission to pay property taxes. I see the little clock has run out. If there are no further questions. Thank you.
Very much, John Heiser. Any questions? Okay, thank you. Mr. Arnett, whenever you're prepared, you have 5.
Thank you, Your Honor. May it please the court. As to that last diatribe, I'm going to object to that because that's outside the record. That was never argued to the court. The court was not asked to take judicial notice of a pleading, and it's frankly a mischaracterization of the live pleading. That was not asserted as a ground for either modification of the trust or removal of the trustees, and that's just another diversionary tactic and an attempt to emotionally engage people in their decision-making process. Another point is this. Mike created the trust narrative and that Suzanne just signed it. Well, she did sign it, and parties, as a matter of law, are deemed to have read and agreed to what they signed. And she has never moved to have the thing rescinded or vacated for fraud or any other grounds. That is the operative document, and we're operating under it, although the probate court's order has dramatically changed it, and I submit in a manner not permitted by the law. I apologize for jumping around a little bit here, but in terms of the jury trial issue, the jury trial right is based on Article 5, Section 10 of the Texas Constitution. And it provides a right for trial by jury in the trial of all causes. And the Texas Supreme Court, and this is articulated in the Troy S. Poe case, the Texas Supreme Court has adopted a very expansive view of what constitutes a cause for purposes of a jury trial, and it has restricted that right only in very specific contexts where there was some specific reason that made a jury trial untenable. That's not our situation here. And that the right to a jury trial extends to all contested issues of fact, regardless of whether it is an equitable proceeding or a legal proceeding. So here, there was a perfected right to a jury trial. It's constitutionally based. The jury fee was paid. The appellant's counsel before the court affirmatively indicated an intent to stand on the perfected right to a jury trial.
Yeah, Mr. Donhauser says that came too late. Address that, please.
Well, certainly. So the point there is that in the context, the court and the parties anticipated further proceedings, that there would be further hearings. And, at that point, the court had been taking evidence. Now, the court obviously has, once there are findings of fact made by a jury, then the court is the one that applies those findings of fact and makes the equitable determination about whether a trust should be modified or not. And so, because they were intending to and contemplating further proceedings, I would submit that that's not too late. And to get back to the SunWest case and how it distinguished the Texas Supreme Court's case in Citizen State Bank, there apparently the bank just told the trial judge, hey, we've paid a jury fee, and that was good enough.
When did they say that? Did they say that at the end of a proceeding when a bunch of evidence had already been admitted and witnesses had testified, or not?
I can't tell from the opinion, Your Honor.
Sure.
Just at some point in the proceeding, they said that.
Understood. Thank you.
With respect to the tagging my clients with the Mike Ruff judgment, if you look at the judgment that the probate court entered, it grants no relief against my clients. And if you look at the arbitration award that is attached to it, it specifically recites that on September 15th, 2017, Suzanne Ruff non-suited her cross claims against my clients. And then the panel says this: therefore, they were removed as parties in this matter on October 19th, 2017. And if you look at the arbitration award, again, it awards no relief against my clients. They were not parties. Now, did they file a notice of appeal? Yes, they filed a notice of appeal to object to one specific finding that the release document was unenforceable. But again, they really didn't have standing to do that because that order was not directed against them.
Mr. Arnett, you're out of time.
Oh, I apologize.
All right, don't worry about it. No, it's okay. I get rolling too. Want to thank the parties for excellent briefing and argument, and we appreciate y'all helping us try to come to the correct decision in this case, and the case is submitted.
Thank you.
Thank y'all.